Hello, good evening, everyone, and welcome to the Property Show Live, episode 7. And it is presented by Dreamville Realty. I'm Sabbir Khan, broker of record at Dreamville Realty, and I'll be your host this evening. Thank you for joining us on Facebook, LinkedIn, and YouTube. We're very happy to have you with us. And our goal is with this show is very simple, as you know. Every week we have invited professionals from different industries to share useful information that helps people make better real estate decisions. Our goal with this show is always been to keep you connected so you can have all the information that you need and we can answer your questions as well. Over the last few weeks, we have talked about mortgages, we have talked about home inspections, we have talked about home inspections and home staging. Tonight, we're covering another important topic that affects many people across Ontario. And our topic tonight is landlord and tenant rights in Ontario and what you need to know about that. Whether you are a landlord renting out your property or a tenant renting a home, it is important to know and understand your rights and responsibilities. Knowing the rules can help you avoid problems, save money, and handle situations with confidence. To help us understand these topics, I'm pleased to welcome our special guest tonight, Mr. Mohammed Alam, a licensed paralegal who has helped many landlords and tenants over the years he has practiced. So I'm going to bring Mr. Alam on the stage.
Good
Hello,
evening.
Mr. Alam. How are you today?
I'm fine, thank you. Good evening.
Good evening. Thank you for joining with us. And before we start, I would like to ask everyone who's watching live, if you have any questions regarding landlord and tenant related issues, please feel free to ask any questions through the comments, and we'll do our level best to answer them throughout the show. So without delay, let's get started. So Mr. Alam, I thank you again for joining us with the Property Show Live, and we're really honored to have you with us tonight. And could we start by telling your little bit about yourself, your background, and what inspired you to become a licensed realtor, a licensed paralegal actually, specializing in landlord and tenant law? And I know you're also a realtor. That comes with the name of anyway. He has another, title with the realtor too, but he practiced mostly legal, paralegal. So if you don't mind to explain it for our viewers, please.
First of all, I want to thank Dream Valley Realty and especially Sabbir Khan for inviting me to join today as your guest speaker on Landlord or Tenant issue. Before going that, let me introduce myself. Basically, I was back home. I was an engineer, and I served Bangladesh TNT board. You know that for a long time. I was the member planning there. But my father was a lawyer. He told me to become a lawyer, like a barrister in Bangladesh. But I opted to be an engineer. I did that. After taking the earlier retirement, I came back to this country and I found that the engineering has gone so far. So later on, I thought, oh, why not I start again a new career in law sector. So I started law. So I saw that it is like 4 years or 5 years to become a barrister. So as because I was a little bit senior at the time, so back in 2011, I started I studied law in paralegal sector, and I passed with honors and masha inshallah that is good. And I joined the Law Society of Ontario. Before that, it was Law Society of Upper Canada. Now it is Law Society of Ontario. And I joined there and I'm practicing. And the law is really challenging. And not only that, I found it very interesting also because it is differs. Every case is unique and different. So that's the reason I became paralegal. So I am not only in landlord tenant board now. I am in a small claims court, traffic court, and interesting is I used to write answers of the real estate agents in RICO complaint also. I attended a RICO case and I won that case of a real estate agent. And right now, I am also busy with another case in RICO for a Pakistani realtor. So that's the thing. So that's how I came to become paralegal.
Well, that's actually a great way to start, and I like the way with the father's encouragement, and finally you made that through. That I mean,
Yeah.
you deal with law. That's all matters, right? So
Yes, yes,
that's really fantastic. And I know you're practicing definitely mostly landlord tenant issues, as far as I know.
exactly.
And now, so far with your journey, what is the most common landlord and tenant dispute that you dealt in Ontario?
In landlord or tenant board, mostly it is, you can say, non-payment of rent issue. This is, you can say, about 70%. And then comes like landlord's own use, damaged property, other issues. But mostly you will see that the main issue is like non-payment of rent.
But, correct me if I'm wrong, Mr. Alam, that if somebody doesn't pay the rent on time, and if the landlord goes to, I heard that law is more for the landlord benefit. When the tenant is not paying the rent, it is much more faster to evict them compared to the other issues. Is that
Not
true, or is it something?
No, not always. This is the part. Like, and for of course, if you don't pay, the basic duty of a tenant is to pay the rent on time. If you don't pay the rent, so of course the landlord can go to the landlord and tenant board and ask for eviction, and you will get it. But there are certain conditions too. Section 82, they say the landlord. You will see that in the application of Elon what tenant can raise in the hearing, and you will see that they can raise so many things. They are bed bug, they have so many problems, they couldn't enjoy properly. That's the reason. But the landlord tenant board member will listen everything, and section 83 says whether it will be good for the tenant to stop the eviction or landlord eviction is okay. So that's the reason they can get it, but it is a little bit lenient towards the tenant, but not always.
Not always. So it's all about the. I think the paperwork is very important, as you mentioned,
Yes.
as an N4 is has to be issued on time. So now, like, what is the basic right the landlord should know before renting out a property? Because
You
many
know what?
landlords they are renting out, but they're not understanding a lot of basic rules. So, what is the basic right you think they
As
should all know?
I believe landlord should check certain issues like income information, credit checks, credit references, rental history, guarantees. These are the thing, but not like you can say the due diligence. Like, first of all, know your client. So you must see already who is the tenant, to be tenant, you can say. And you can say, you can ask for anything like your pay stub, your current job information, or that do you have any guarantor, and all this stuff. It is not illegal. You can ask that. And then finally, sometimes they can, you can ask even their, you can say SIM card, but most of the time they don't want to give. But of course, the photo ID must be given, and there must be a
Okay.
rental application also, so that you know everything in advance. They okay, these are the thing. And if you have a reference, why did you leave before? You can ask that previous landlord also. How is that gentleman or that lady? So I think that these are the common thing. A landlord
But
must.
when the landlord hired the realtors, they actually does this on their behalf to
Yeah,
do the all due diligence, reference checks,
yeah,
employment checks, makes it more lot more easier for the landlord.
yes.
Okay.
That is good because a real estate agent should do it. But at the same time, in real estate there is a form, but he must also add this rental application, and there is another form like residential, this lease agreement. So
Ontario tenancy agreement you're talking about,
yeah,
right?
nowadays it is called not Ontario rental agreement, but residential tenancy agreement.
Tenancy agreement, you're right, yes.
You should add that one, and it is the seven total 13 pages, but 7 pages. It is everything is their name, and then how much is the rent, is there. But best part is I will suggest to write one thing because the do there is a column like in the middle of this one, like your email address, their email address, so that you can communicate through email address. I have seen through my experience, if they leave even, there is a form called L10. So you can apply to that one and you can ask the landlord board that there is an agreement. In the agreement, we have seen that it is written, the email address is there. So I can send the application by email. And landlord board, of course, allows that one. This is my extra. I did it. So unless you have it in the there, that okay, you can communicate through email and you should give your email and the tenant's email, then it is done. You are saved. So I
So
would
it,
suggest,
it, it plays an important fact there, like to have
yes,
that email in
yeah,
order to give the documents or any
yeah,
notices or
through
something.
email. So
Right,
better
right.
in the afterwards, if they leave even without paying any money, you can go after them through L10. But
Yeah, that's
how
a
will communicate? Because how will give them, serve them? So through email. Well, that's the real
that's
thing.
fantastic. A lot of agent and landlord, I don't think they know that. That's a very valuable information.
Yeah, and
By
then
putting the
the
email address there, you're actually authorizing even the LTB to take action and send the documentation through the email.
yeah. So that's the reason. Even real estate agent should tell their clients that in that
Mhm.
portion we can communicate through emails and put the emails there. It will be much more
Correct.
easier for you.
Right. Now, thank you, Mr. Alma, for this explaining very in detail. Now, obviously, as a paralegal, I'm sure you not only represent landlords, sometimes you represent tenants as well.
Yeah.
So, what rights the tenants should understand in the opposite side of the coin?
Yes. First of all, tenants should know that their main duty is to pay rent on time. In sometimes if they, and then normal cleanliness. They should have the normal cleanliness, and then in case of any damage done, willingly or unwillingly, sometimes the friend came and then did something wrong. So they should also uh, do that maintenance also, a smaller maintenance. But they, in some cases, I have seen that they change the locks. This is obviously wrong. They cannot change the lock. And if anything goes wrong, like the landlord sees that he has changed the lock, he can go to landlord or tenant board and ask for the immediate. Either they should give the key or they will change it again to the back position like what they had it before.
So they
So
can change the lock, but they have to provide a key to the landlord. Make sure
exactly,
the landlord
exactly,
has access. Yeah.
exactly,
Okay.
exactly.
Yeah, that's very important. But just a question to this answer that if this kind of situation happens, if the landlord doesn't have an access, and if you end up going to LTB, what is the time process for this kind of issues to
This is
resolve?
the yeah. This is within a few days because you apply and then the lender will come forward. The LTB will order this tenant
Immediately.
immediately. And I
Okay.
have seen people like tenant did that in the past because they didn't pay and at the same time they blocked the landlord to go inside. I have
Oh,
seen
yeah.
that.
Perfect. No, thank you. And now, lately, we have some few of our agents and some people from other brokerages too. When they're representing the tenants, we came across few issues that we face. We applied for a one of the property for listed on MLS. We applied it. Tenant has a perfect profile overall. They have a good credit. They have a fantastic salary, clean record, no concerns. Previous landlord, good reference, but sometimes we still get refused. So can landlord legally refuse a rental application without any reason? Or if they can, what circumstances that can cause that?
Basically, no. The answer is no. They shouldn't. The landlord cannot withhold any application. But especially, there are human rights violations, the codes like race, gender, then age, then religion. And there are 10, I think. I can tell you even all of those things. One thing is this race, color, national
Yeah, a lot
religion.
of that they don't mention that, but it comes to
Yeah,
that
but yeah,
unfortunately. Yeah.
they should not, they cannot. But sometimes, there is a tendency nowadays. We have seen that I am not telling about them because there are some countries but the people feel, oh my God, these people will not be good, and there are preconception, and that's the reason their problem comes, and they don't want to rent it to those people. That is a problem, but normally it should not be. The landlord
But
should.
is there a process for this? Because, the bottom line is if the rental application is not accepted, that means person is not getting the place. In order to get the place, they have to get approved. So if they get declined, if is there a process for them to like go
There
take
is
action?
no, there is no process, because I have seen that these people used to say that it is sold. So what you will tell, because already it is sold, they are telling it is sold, already given to somebody else. So you cannot have a proof that they didn't give it to somebody else. So that is the problem. You cannot.
It's a very tough situation, basically,
Yeah,
sometimes.
I know. But
And yeah, go ahead,
no,
Sam.
the thing is this, as because I already mentioned that people used to say, well, like they have a preconceived idea, and
Right.
the preconception, like looking at you are thinking, especially for some countries people, and that is a big problem.
Yeah, they judge people right away. Yeah, I
Yeah,
understand.
exactly.
Yeah, we face that sometime, but unfortunately, we can't do much because we know those people are really great when we interact with them.
Exactly. This is
But it's
not
hard
correct
to,
dollars. This is
yes,
not correct dollars.
absolutely, absolutely. No, thank you for answering that as well. And now, as far as the deposit, I know that legally a landlord can ask for first and last month, but many cases, for example, there's a newcomer comes to this country, they they don't have any previous credit report or they don't have any kind of proof of income yet. Maybe they got a job, but there's in a process of establishing this country. Many cases we have seen, landlord asks for, you got to pay for the entire year, or maybe they'll say, oh, pay me at least 3 months more deposit, so I can, after a year, we'll adjust that deposit to the month. So what's the law says about this?
Losses are only first and last, like the last month length deposit, LMR. So first month is normally common idea is like 2 months, first and last. First month deposit is in the next when he comes, and the last month deposit will be adjusted in the last month only. There is a misconception also. People used to say they didn't pay, so that last month rent deposit is already exhausted. Not
Already
correct.
collected. Yeah.
Yeah, so already, because this misconception is last month rent deposit means last month. You have to, at the end of the time, you can do it, but not before that. You can adjust.
It's
Only
not
the,
necessarily end of the year, but it's end of the entire tenancy.
yeah, whatever maybe the tenancy period. Sometimes if you don't renew it, it goes to month. So in that
Correct.
case, you cannot use that one also. When the entire tenancy you are correct, that time you can use the last month rent deposit, not before that.
Correct. And now, if somebody voluntarily deposit more money to establish credibility with the landlord, that's absolutely okay, right?
Yeah, that is okay, because this is the agreement is offer and acceptance. So if you
Right.
offer that, okay, I am paying you 3 months more, that's fine. But there is another term like the key deposit. People used to, that
Yeah.
is refundable. You have to
Yes.
refund it at the time he leaves. Then you have to pay back the, like, okay, this amount was for the key deposit, so you take it.
If you
Especially,
lose the key, if you lose the key or something like that
exactly,
happens, then you can deduct it, basically.
exactly. That's the reason. That's the reason. In condo, especially, this happens
Yeah.
in FOB
Because
and
fobs are sometimes very expensive. They're like
exactly.
$100.
So that's the reason they used to keep some money for there, the
Right.
key and this.
Right. Now, I'll go to the next question I have is about the rent increase. I know certain houses built up to a certain time, they're allowed to increase rent whenever they want, but other properties have a yearly maximum, controlled by Ontario. If you can talk a little bit about this
Yeah.
for our
So
viewers.
this is called rent increase guideline. There are two. Like in Ontario, there is a rent increase guideline every year. First of all, you can increase only after 12 months. First of all, in the next year, you go there. If you don't renew, even that is month to month it goes, or you renew it, then there will be rent increase. Like how much is that? In 2026, it is 2.1%, and 2027 it is 1.9%. You cannot go more than that. So to 2.5%, if it is like $1,000 multiplied by 2.5 divided by 365 or 12 months, so monthly how much it comes, you can add that or no. There is a procedure. There is a form called N1, and with that N on, you have to pay 90 days advance notice. Like December, you are going to the end of the year, like, but then October, November, December, you have to give before October. You have to tell that the rent increase will be from January, and this is 2 point. So before 90 days, people has
But
to
it
know.
has to be after the term is over, right? After the term.
No, after the term is like December, but you have to give him this N
Three
on
months
notice.
notice.
Yeah,
Yeah.
it's this October, before October,
So
90
let's
days.
say my tenancy ends December 31st. I'm just
Yeah,
giving an example.
yeah,
And I have to give him notice saying 3 months before December. So
exactly.
in October saying that I want to increase the rent based on the Ontario
Exactly. That is the form
rule
is
basis.
there. You fill out the
Yeah.
form, very easy form,
Yeah.
like name, address, and how much is the present rent, then
Mhm.
2.1%, because in 2026 is multiplied that one, and you add that
Correct.
one, and the monthly rent will be this.
That's a great information. And so,
Oh, there is
and
another one above rent increase guideline. There is another one.
mhm.
Suppose the landlord has made another kitchen, nice kitchen, and all this stuff, and there are other items which is added value. So in that case, he can say that, "You look here, I did this, I spent those money, so another 3% I want to increase. Not only above normal guideline is 2.1% plus 3%. I want to do that." So there is an L10, and then you can do it. You can tell that if this L10 is, this is an agreement, like we will do it. Anything you can do, with the consent of the tenant, you can do it. It doesn't has to be on rent increase guideline, but it depends upon the tenant and the landlord, both of them. Like they must
So
agree.
with a mutual understanding, you can go pretty much any amount.
Exactly.
But
Yes.
without mutual agreement, you can always enforce the minimum requirement. I
Yeah,
mean, the maximum you
2.1%.
can go for the Ontario rule
Yeah,
basically. Yeah, that makes sense.
2.1%.
And some properties they are not under rent control. Which properties are those?
Yeah, there are if it is Airbnb, and then there are other small item, like you put it in the beside the any park, and so this type of property which is not under the purview of tenant board, landlord, this RTA, they are not exempt.
Also the newer properties too, right? The new condos,
Yeah,
those are
so
there.
for the time being, then after
Yeah.
that, of course. And the basically it has to be 1 year. You can increase that after a year. So if it is
Up to
like,
date. Okay.
yeah, so 12 months must be passed then only.
Right. That's thank you for answering that. So you have covered a few questions already. I already had in mind.
Please go
So
ahead.
now we are commonly seeing that a lot of tenants, overall economic situation in the whole globally, a lot of people not paying rent on time or they're delayed. So when the tenant doesn't pay or stop paying the rent, what's the first thing landlord should do?
Oh, immediately, like today is the first day, you're supposed to pay on first, or maybe on second or third, you should send an email or any letter as to the please. This is the third day of the month. You should pay the rent as per our agreement on the first of every month. You didn't pay, so please pay it immediately. Just a small, not like any harsh or any rude letter or anything. But there is a common problem. Like the landlord used to sometimes say, but so many things like which is not proper. This can be an harassment also. So after that, if it doesn't pay, so immediately you should give N4. Like,
And for immediately.
yeah, notice, N4 notice, that is non-payment of rent. So
And
immediately.
now this N4, if the agreement on our RTA, Resident
Yeah.
Tenancy Agreement, if
Yeah.
we have documents served by email, so that can be served by email, is that sufficient enough? When we
Yeah,
send by
but thing
email?
is that there are certificate of service. There are certain ways, like you can give it by hand, like straight away to the person. You can put under the door of the rental unit. You can put in the mailbox where the normally mail is there. You can send it by mail or express mail. So there are so many ways you can send by courier. So not like that. The email has to be, the email is a special thing, like in the other alternate service. But for you, like you are here, tenant is here, so you can go there, give it directly, or sometimes under the door, sometimes put in the mailbox. Everything is good.
Because I have seen this before that many time, even it was sent by different format, but tenant actually, declined that they received it. They always say, "Oh, I didn't receive it." Oh,
No,
we sent the email. I didn't receive it. Did you
I
get a
know,
mail? I didn't receive it. So,
I know,
how do you
because
keep that report? Yeah.
that is not acceptable. That is you cannot say, because in a landlord board, suppose I have already requested my clients to take a photo. Like when you put in the mailbox, you take a photo. You're putting it inside the under the door, you take a photo, and that's I just upload that one. I have seen already the certificate of service there, and at the same time I put photo also. So
Right.
in that case, there is no problem. They cannot deny it.
So I know that let's say he stopped paying rent. We send him the N4, and he didn't pay the rent next month either. So I know there's no process in Canada overall or in Ontario that you can evict the tenant immediately, even for the non-payment. So what is, if you can explain for the viewers, what is the proper eviction process through the landlord tenant board, so and the time process? If you give a little bit of detail about that, that'll be really grateful.
Yeah, so basically, first of all, you have to give informed notice, and there is a time limit for 14 days. You have to wait for 14 days, and after that, you can apply for this Elon application. You can upload to the portal, and after that, there will be a time. Nowadays, it has become less time, because I got a hearing date only 1.5 months after. Suppose I
Wow.
applied today, before it was 7 months also, that
7 months,
once it
yeah.
was, yeah, but after that it came down to 2 months. Last time I got 1.5 months. So that is very, starting like the good for the landlord, because you are getting less time.
Things are getting better. Yeah.
Better, yeah, much better, and hopefully after that it will be 1 month even. So what happened after that? Suppose 1.5 month I get the date. So on that day, I will go with my client, like the landlord, and then if the tenant doesn't come, then it will be ex parte decision, like on way, and I will tell that he didn't come, so we'll get the order, eviction order. Number two, suppose he comes, and then he will raise some issues, and section 82, as I mentioned, what are the issues the tenant can raise in the hearing. So that time, if it doesn't, you have to answer that. And if we put that one in writing, then I request my landlord to answer those, and I upload that one also. And after that, we talk to the member. Yes, this is the thing. This is the proof. This is wrong. This is right. And after that, we get the order. And most of the case, I have seen that, because you have 15,000, 18,000. So you get the order immediately, and we wait for the. After that, it is written how much you have to pay today, and it is written you can void, the tenant can void the order by paying this amount on so and so date. And if it doesn't pay within that time, you have to go to the sheriff's office. It is in Toronto. It is 393 University Avenue. You go there, pay some money there, I think 315, and the sheriff will give you time. You wait with a locksmith and a new lock there. Sheriff will come, evict the tenant, and change the lock and give it the key to you. But thing is this, the inside, like his belongings, like all the stuff sit there. It is your duty. You have to keep it in a safe place for 72 hours. After 72 hours, you can throw it, you can sell it, you can destroy it, doesn't matter. But before 72 hours, you cannot do it. So you have to be very careful about that, to keep the stuffs in another place and give it to the tenant. Tenant should come. If it doesn't come, then no problem. After 72 hours, destroy it.
So there'll be no legal consequences for
No,
that.
no. After
Very
70
good.
hours, yeah, no consequence. You can destroy, you can give it to somebody else. You can throw it in the garbage, like in the street. Doesn't matter. But 72
So,
hours is crucial.
right. Well, thank you. All these costs that's occurring for this legal actions, sheriff, and all these payments. So, can you go after this tenant afterwards? And what is the success rate to collect that damages afterwards?
Yeah, the only problem is here, like I can give you the order, like you can get the order, like
Mm-hmm.
non-payment of suppose $10,000, and
Mm-hmm.
$186 the cost which you for the landlord or tenant board. So you have $10,186. But the next process is landlord tenant board doesn't have any power to enforce this order. You have to go to the small claims court. In a small claims court, it is told that it is the order, as if it is the order of the small claims court. You don't need to go to the small claims court for another order. This order is quite valid. So now you should start the enforcement process. Problem is you should know the address, where you will get the address. Because if you don't know address, you cannot serve it, because that is the rate of seizure and sale. You can have garnishment, you can have sale of goods, sale of land. These people doesn't have anything, like they don't have any house, they don't have anything, so you cannot really get the money back. But
But for
sometimes,
the application, because at the beginning of the tenancy, when they apply, they have their employer name and all that. I know it's hard to find their current address because they're evicted, but by law, we can approach the employer about that, or
yeah,
the
yeah,
law.
sure, sure. And then we can serve them there. Sometimes you will find that they are not here, even they have given the address,
Yeah.
they are not working there. That is another problem. But once you
Hmm.
have it, we can obviously. The garnishment is like the court will order the boss, like the head of the organization there, where he is serving or she is serving. So they can order the, okay, you pay this amount to the landlord and the rest to the employee, like the tenant. It
Right.
is possible, but it is some time consuming, again, few months, you can say.
Yeah, that's actually very long. Sometimes it could be a very long process, what I understand, depending on the
Yeah,
situation.
another 4 5 months, another 4 5 months
Absolutely.
at least.
Absolutely. Now, what are the responsibility do tenant have when it comes to property maintenance and damages? Like a standard responsibility.
The standard is a normal warrant where he should do it, like the any damages I mentioned already, like somebody or some of his friends and who came, and then some damages is there, so he should do it. And normal cleanliness, he should do it. And if anything goes wrong, like most of the time, he can request that the water is leaking or something is. So you can request the landlord to rectify those faults. But if he doesn't, then he can do it even by himself and give the receipt to the landlord. Okay, this is the cost I have incurred, so please pay those. So that is another possibility. He can do it, but normally, normal warranty, normal maintenance, he should do it. It is easy, and in some cases, there is an agreement, like with this rental agreement, there is another point, like there's some sort of agreement where it is written, I did this previously, there is another small agreement, and we should say that, okay, the normal, this we have given you, this all brand new. In case of failure, in the next time you have to do it. If they sign it, they agree, then it is fine. Then they can it is their responsibility then. But thing is that most of the time they don't do it, because they can say that it is an old appliances, so it is not my duty to do it. Sometimes it
Mhm.
happens like that.
But under the Ontario law, as far as the maintaining outside lawn, snow removal, um, for example, if you rent out the entire house to someone and they want to make sure that they clean the snow, they cut the grass, is there any restriction on this under the law?
What
Like
restriction?
for cutting grass, tenants should cut the grass, tenants
No,
should
no,
clean
no.
the snow.
It is again mutual agreement.
Mutual agreement. So there's no concern about that at all.
No, no, no. It is normally it is the duty outside is duty of the landlord, because they have to enter
Normally.
outside. Yeah, outside insurance also. It is the no, landlord's.
Like the building insurance basis covers the
Exactly.
outside.
Yeah, the
Okay.
outside, and then you should cut the grasses. You should cut the snow plowing. All this stuff is the landlord's responsibility. In some cases, I have seen the landlord doesn't stay here. He lives in, suppose, in another estate. So he requested already with an agreement with the tenant. Okay, you please do it. I will pay you, or maybe reduction of rent. Sometime they tell you for this reason I will take $50 less, something like that.
So
I've said
mutually, it's fine. Like if mutual
exactly.
understanding, they can do it. That's
Always
absolutely okay.
mutual agreement is the best agreement.
So so if because the reason I ask this question, I've seen people, when they actually ended up in LTB, although they had under I mean, under agreement to lease and under Ontario lease, stating that tenant is responsible to cut the grass and clean the snow. But that became an issue later when they were going through the eviction process. They didn't pay the rent and they claim all these things. Landlord even made me do my grass and the snow,
Yeah, that's why
although they agreed
again,
upon it.
if you have an agreement, you can show it right away.
So that
The,
that
it,
that will stand in the court basically.
exactly, you
That's
can
good to
see.
know. That's
Because
a good to
you
know.
say that in agreement there is about the, is there any other agreement? There is, you put a tick. I forgot. It is that maybe a page number 6 or 5. That is just when you tick that one and you add one a separate exhibit. All the it
For
is written.
to the lease.
Yeah,
Okay.
you do that. You
Right.
write those and then exhibit. You put the tick mark there, add it, and then get it signed by the tenant and landlord both. And they know that this is a mutual agreement. They have to do these, or
Correct.
restriction, this.
Right. Now, thank you, Alambhai. And the next one I want to know about is obviously landlord has a lot of responsibility as for the maintaining the property, and maintaining the refrigerator, appliances. We got to make sure this. But sometimes we put a clause that any expenses to fix the appliance or anything up to $100 covered by the tenant, and anything over $100 be covered
Landlord
by landlord. So once again, that's a mutual understanding.
again.
But is there any concern in the eyes of law about that?
No, not like that, because they normally, uh, what is the landlord's duty? To give in a livable condition. The house, the property should be in a livable condition. What does it mean, livable condition? Because all the appliances are in good shape, all the like facilities given, and there is a word in law: facility once given cannot be curtailed. So if you give him that internet, so you have to ensure that internet is working. If you give it like the air conditioning, the whole house is like one common air conditioning. So it should be properly workable condition, like internet is there, air conditioning is there, heating is working properly. So all this stuff, that is the duty of the landlord. In some cases, as I mentioned before, that okay, these are the items I have given you. You see that, and then they take some sort of signature. The freezer is good, the microwave is good, then toaster is good, all this stuff. The stove is good. And after, if there is anything wrong, and then they tell you, okay, if it's a minor thing, you just do it. And then, as I mentioned, the $100 or something, he completes that one. If there is an agreement, if not, then he can tell that okay, it is your duty to do it. If he doesn't do it, then he finishes that one and send the receipt to the landlord. Okay, I have
To pay
already
the remainder
incurred.
of that.
Yeah, this is, I have incurred this, so please pay
So
this.
you encourage always do an inspection before hand over the keys.
Oh,
So they can
sure.
go through everything. That's
Yeah,
very important.
that's
Yeah.
very important. You can write it down even. Slowly.
Right.
Okay, and in some cases, I will suggest one more thing, because nowadays I have seen that I'm doing some cases like fire protection act. Like there is a fire protection, and this thing, there is a carbon monoxide detector. There is a fire alarm, And unluckily, the battery they didn't check even, and it doesn't work. So what's the use of this fire protection alarm, this fire alarm, or the carbon monoxide detector if it is not working properly? And if
Right.
there is anything goes wrong, then inspector comes from the city. You get a hefty, like big amount, and then they count the 10 counts. And then I did this type of like cases right now. Some days back also I did 10, 20 cases. I did. I have seen that the fines 15,000, twenty
Wow.
thousand, 30,000, because in all count, and then they don't agree. I told that they have finished already, but the condition is like on that day. Had it been there is an accident, there can be loss of life also. And the
Correct.
judge accepted that. The judge said that is the precondition. Now you change that one, that is fine. But thing is this: before that, on that day, it could be a different issue. You can there can be loss of life. So what should be?
Yeah.
That's the reason. The
Now,
fine
now,
is
now you talked about the smoke detector and the CO2 alarm. Now, the day you hand over or pre-inspection done, everything is working fine. For the ongoing term, whose responsibility is that
no,
to maintain?
inside this battery and others, the tenant should, you can write that it is, I have seen, say that it is there and it is working properly. The battery is there. I am not living here. So please check sometimes, and if the battery is a small amount, we can change that.
So
Again,
it
the
should be
same
part of the contract. We should mention that in the agreement.
you can that I told you, this separate the clause there will
Exhibit.
be agreement and in the exhibit. You can write it there. I have seen, I did it so many times that what are the restriction? You cannot do any illegal activities within this tenure and in the premises. If it is so, then you are bound to, you have to go, because you agreed to that. No loud, this music and other things.
Music or anything like that.
So all this stuff you can incorporate there.
So
So
generally, what we do is we are doing the ATL, which is the agreement to lease,
yeah,
on the it's a ORIA form, and then when we do the RTA, residential tenancy agreement, so we put that attachment as the APS agreement to lease with the
exactly,
schedule. So that
exactly,
works like exactly the same way you're mentioning, basically.
exactly. And then when that agreement in the residential tenants agreement, you will see that a standard lease. It's called a standard lease,
Standard
and that,
lease, yeah.
yeah, it's a standard lease. There is in the page number 5, I think there is a small. Is there any other attachment? You click that one. Yes, there is an attachment. You put the exhibit A there, and you write all this stuff, whatever you have there. Okay, these are the things we agreed. So everything is in good condition. Now anything goes wrong, you have to please you change it, or fix it. So it is always mutual agreement.
Absolutely. Now, thank you for answering that. And question after this question again, like let's say there is a problem with one of the refrigerator or the stove is not working, so the tenant informed the landlord or tenant got somebody to fix it, or they might have to replace it. It taking some time. Now, does the tenant has any right to withhold the rent because something is not repaired?
No, no. This is another misconception. The tenant used to say, nowadays I have seen that in the case, I didn't find the lack of enjoyment. It was not working properly, so I had a lot of problem. So I stopped rent. So he cannot stop rent, or he or she. Like just said, no, I objected in some cases. How can your duty is to pay rent? It is okay. I understand there was a lack of. You can ask for some rebate. Maybe 3 days I couldn't use it, but you cannot stop full rent. And that is the misconception. Nowadays, I have seen people used to on that plea, like kind of alibi, and they stop payment, stop the rent. That is not
So,
correct.
so tenants should always pay the rent regardless of what.
Exactly.
So that is
Regardless.
totally a separate matter. They can talk to, they can go to LTB regarding that too if they
Yeah,
want to.
that is different. That is that there is application T2 and T6. T2 is a
Right.
non reasonable enjoyment, and T6 is maintenance problem.
Okay. Now, when can a landlord legally can enter the tenant's unit
Oh,
legally?
there is a specific guideline for that. Section 26, 27. You can say that it says there are some items like First of all, again in the agreement, you can write it down. Okay, in every 15 days, landlord can come in and check the maintenance issue, all this cleanliness, all of that. That is one. Otherwise, a special circumstance, suddenly in the basement, the tenant is there, there is a furnace room, another thing, that is not working, that is problem. So in that case, without any information, you can go even. Just knock the door and tell that this is the problem, and you can call him or her and tell that this is the situation. I have to go now. This is the emergency situation. So that is the without permission he can go. With permission, then he has to write a advance 24 hours advance written notice that I am going on that day on a so and so time for an inspection. So that time, of course, you can go inside with that permission, and you can paste it on the wall of the door, and the front door. You can paste it there. You can put it on the door. You can email the tenant. Okay, this is the situation. I am coming on so and so day. Due to inspection or due to see the condition of the house, and with the permission you can take photo, but sometimes they tell the no photo or all other, but you can say that, you will tell that yes, I will take photo. And then, but thing is this, in emergency situation you don't need any permission.
For
Otherwise
emergency agent.
24-hour detained notice.
Now, but you mentioned something at the beginning of this answering this question that if you put in the agreement every 15 days I'll come by to
Yeah,
visit, or if you have that on the agreement, do you still require notice, or you can go
you can
every
go,
15?
you can go.
You can go as
It
long
is.
as you have that in the agreement.
And then it is written, if the tenant consents to the entry at the time of entry, even you tell that I am coming. So if he allows, then it's fine.
Okay.
And same thing like a specific tenancy agreement, if there is it is specified, but the time should be from 8 a.m. to 8 p.m.
Between 8 a.m. to 8 p.m. Okay.
8 p.m.
So not unless there is an emergency or anything,
Oh,
that can be any time.
that I mentioned anytime.
So so that's very clear. So I think that's a good idea. I think it's very helpful for the viewer to have, if somebody wants to have that kind of condition in the agreement, they can do it like maybe couple every 2 months they can do an inspection
Exactly.
if they put it in the agreement basically. That's a good thing to know.
And
Thank you, Almay,
before
for that.
that, he should write send an email or talk like over telephone.
Then
Yes,
I'm coming.
I'm coming.
Then I'm coming. Yeah.
Okay.
So yeah, that's a great answer. Thank you so much. And if you can tell us one of the things that one of the most biggest misconceptions landlord have in Ontario's rental law.
I have seen that because they thought that sometimes, first of all, they asked one question, that is, on your term is finished, it is the termination date is already done, so you should go now. It is not correct, because here this is a misconception. Always you have to understand that if they even if the lease is terminated, but it is still there month to month. This is a fixed term tenancy for 1 year, but after that it will be month to month. So you cannot
It's
tell
a
him
very
to
common
go,
question. Yeah.
yeah, you
Yeah.
go away right now because the term is finished. So that is the
Mhm.
number one misconception. Number two, a landlord thinks that no, I can do it by force. I have seen that by force he has told the tenant to go, and that by
Yeah.
pressure that is another misconception. You cannot do. You are the landlord. It doesn't mean that. And sometimes you go inside. I have seen that
Mhm.
the lender went inside without permission, and that is another means. Oh, I am the landlord, I can go inside. Number
Yeah, I
four,
think landlord and tenant both have a misconception about this because there's a 60 days notice. They can
yeah,
give this notice anytime. But they don't understand that they have to fulfill this 1 year term because they have
exactly.
signed a legal agreement to
Exactly. And then
that's the
I
thing.
have seen on landlord, and went inside, and there was a lady. She was alone. And because there are two small children, and she said, how we live without any man? And so many bad questions, And
Yeah, I
then he was penalized, and I did that course. I was for the tenant. and he was penalized for $10,000.
Wow, and
And
they're
then, oh,
expensive,
very
expensive bills.
expensive, yeah, because not only
Mm.
that, he went inside and the just putting the key inside and come inside, and then the lady was what, how come you are here? So he wrote, I am the landlord. So this is a great misconception, as you mentioned, asked me. And from
Yeah, I
10
think we
side
need
of,
the rule sometime with the, especially within the community. Sometime we have seen a lot because it's a misconception from back home and all that. They sometimes mix up the rules because
exactly.
every country has a different rule, right? So for this,
Right, there is another
so
misconception from tenant side also.
right,
Tenant is
right.
think no, he didn't do it. The fix the my problem. I not pay. This is not
Mm.
not
Yeah,
correct.
yeah, absolutely. So, Mr. Alam, we have a question from one of the viewer. You know him very well. It's Qazi Tanvir Mahmood. He's
Okay.
asking, can a tenant set up an extra lock without prior permission of the landlord?
The answer is
Uh,
no.
Answer is no.
Yeah, I already
Okay.
mentioned because he asked me this question. The answer I told that he cannot change the law because
Right,
first of
right.
all, if he changes the lock and stops the landlord to go inside, you can have there is the from L8 application. You can go to the landlord board and inform that immediately the landlord will board will answer, just inform you, inform the tenant either he give a key or put it in the original position. Same with the landlord also. Without giving
Right.
key to the tenant, you cannot change even the lock also. So changing
In
the
case of
law,
emergency situation.
yeah, changing the law lock, you have to give a key. Otherwise, you have to put the back to the original condition, or if you change the lock happen, you have to pay the money. So that is the answer is very far no.
I hope Mr. Mahmood, you got an answer. So unless there's an emergency, and but they have to always provide a key to the landlord.
Yeah,
The
you cannot
landlord
change it.
always, yeah,
You
the
cannot put an
landlord should
extra
always have
lock
an
there.
correct. Now, if you'd have an option to give a one piece of advice for the landlord and the tenant, what that would be?
Yeah, my request is like, the communication is the essence of everything. Like any dispute, you can narrow it down with the communication, better communication. You should have a good relationship. It is not like a master and slave. Like if you think that tenant thinks that, oh, my landlord is thinking about me like I am in the master and I am the slave. I have seen that they have told that in the hearing. Not only that, they have told that this is harassment and all this stuff. So my request will be with both sides, communicate. Number one, nicely communication, and communication always narrow down the dispute. If you have a problem, even in the non-payment of rent, you can talk, you can tell them they do have any payment plan. Give me a plan. Okay, you have, I understand in this circumstance you have some problem. So okay, give me some time, then it will narrow down. And then after that, in some cases, mutual agreement is also there. You can do it by in writing the, okay, we accepted this, and both sides agree, write it down. That is good. So my request is always communicate. Good
I
communicate.
think I totally agree with you. The communication is the best tools
Yeah, it's
because
the
we have to treat
essence of
people
everything.
with respect, and people doesn't like to be disrespected. When
Yeah,
they get disrespected, it get worse actually
yeah,
situation,
good
right?
thing
So,
you have mentioned right now the respect. I have seen that the tenant feel disrespected, like the landlord used to say, as I told you, master and slave, and the way they behave, they're like this is a, like they are the king, and I am paying the rent, and the tenant used to tell the member, they, look, Your Honor, this is the problem. He behave in such a way that I am the slave and he is the master. So,
right.
company, as I mentioned, respect. You should think the tenant doesn't mean that he's paying rent to you, and it should be respected. It is not like that you cannot, like you can disrespect this guy. You are 100% correct. The respect.
And that solves a lot of issues, respect and
Yes,
communication,
sure.
a lot of issues.
Even in day-to-day issue, you see that in day-to-day life, everybody, friends, uh, even father, mother, inside the
Even
family
family,
also.
friends, everybody. Yeah, of course,
Yeah.
of course. Now, Michelle, thank you so much. We are almost to the end to the show. And generally speaking, when we have some time, we have a, second segment of the show. We have a 5 minutes left for the before we end it. So we created some rapid fire questions for you to answer.
Yeah.
Okay, it's just basically we just fire the question. You just answer one out of two, right? So you ready for that?
Yeah, no, no problem.
I know you're always ready. So fixed term lease or month to month lease?
It is again, it depends. Like fixed term days is sometimes good. Like they have the, but thing is this, you can do it like the 6 months lease and then extendable up to 1 year. But in some cases, you have the fixed term lease, you have a problem. In case of like landlord's own use, that time you have to consider that
Wait
on
for
the.
the time to over.
Yeah.
Right.
And the tenant side also, if you want to go up before, landlord got sued. There is a fixed term days, so he cannot go before that. So you have to pay
Correct.
me the rest. So that is another
Thank you.
problem.
Written lease or verbal agreement?
Yeah, the written lease is always better. Verbal agreement is also agreement, but problem is hard to
Proof.
impose proof, because I have seen that in that case that, oh, I called him, and then they just told the, where is the log? Do you have any log? Call log? I said, no, I don't have it. Well, how can I prove? And the other guy tells, no, he didn't call me. So how will prove? It is like he says, she says. So it is written
That's
always better.
we take the written lease. So basement apartment or condo rental?
Basement apartment, it is again, it is up to you to decide what to do.
We want to know your choice.
No, 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 no. Basement apartment is the it is somebody likes it under there, but it is a like workout basement, then it is better. Otherwise, it is not so good. Like
All right. The next one is first time landlord or experienced investor?
you want first time landlord or experience.
Experienced investor.
Experienced investor is always good. He knows the law, he knows the everything, and the
He's
first
already seasoned with it.
exactly. And through
Meditation or hearing?
meditation is like if it works, there is a word, I should say, dispute resolution officer, DRO. In landlord board, if you go there, you will find the DROs. It saves time. Like both sides agree, you go there, mediation, and then you could tell that was okay. And then mediation, this officer, DRO, they can solve the problem. You sign the agreement, done. You can go away right away. You
Takes
don't
time.
want, yeah, you don't go to your save time.
So the next one is email notice or the paper notice. If you have one either option.
As I mentioned, email notice in some cases, that is depends upon your the residential that
Situation.
yeah, and
If
then
you're out of the
agreement.
country, use the email.
That agreement is, it should be written that you can communicate via email. Then only, otherwise it is an alternative arrangement, and you have to ask permission from the landlord board.
Do you prefer to have annual property inspection? Yes or no?
I will suggest you to not annual property inspection. You suggest every 4 months. At least there is
Every
the
4 months.
yeah,
That's
because
pretty
there are
good.
the at least you can get normally as per law you can go 3 times at least. So you go for that 4 months.
So now I think we're almost to the end. Thank you so much. I think we got a lot of valuable information from Mr. Alam today. We always appreciate your time and everything that you answered. I hopefully that will help few of our viewers. And if anybody want to reach out to Mr. Alam anytime regarding landlord, tenant, or even traffic code issues, feel free to reach out. Mr. Alam, if you can share your phone number with the
Yeah.
viewers, that would
So
be
my phone number is 647 669 5707. Email address adac@paralegal@gmail.com. For as because you are the broker of record of the Dream Ferry Realty, I'd like to share one thing. As I mentioned already first time, that I used to write answers to the RICO also for the real estate agents, because when there is a complaint, I did it for so many real estate. I don't want to. tell you their name for the privacy issue. And then, as I mentioned, one Century 21 Titans. There was a guy like the realtor. I am not telling about the name again, and he was charged from the buyer, or I mean seller. And then there was a complaint against this guy, and then I attended that on his behalf, and in the RICO I won the case. This is a
That's
remarkable.
great, actually. Now,
Yeah,
thank you, Mumbai. Thank you so much. So, viewers, as you heard, if you have any concerns about landlord tenants acts or anything with the traffic court, and even if you are a realtor, if you have any concern with RICO, that you want to, you need someone to, fight for you, he can help you with that. And he's also a realtor with Dream Valley Realty. We're really proud to have him on board. And in the future, if you need any question to be answered, please feel free to reach out to him and call him or email him. And I'm sure he'll be helping you through the process. Once again, Almay, thank you so much. We're to the end of the show. Viewers,
thank
have a
you,
great evening. Thank you for watching us tonight. And we're looking forward to see you next week again. Have a
thank you
wonderful
very
evening.
thank you very
Thank you.
much, Sabbir Khan, because for inviting me and allow me to share some of my knowledges here today. Thank you,
Thank
all
you.
the viewers. Thank you. Take
Thank you.
care.
Have a great evening. Bye bye.
Same to you. Bye bye.